This is an interesting case regarding a particular twist on the access of the press under the First Amendment. There was a policy in Caldwell County, Texas, which categorically excludes the press and the public from observing criminal pretrial proceedings known as magistrations. The case is Texas Tribune versus Caldwell County. The plaintiffs, two nonprofit news organizations and an advocacy organization, argued that this policy violates the First Amendment right of access to judicial proceedings. The United States District Court for the Western District of Texas initially renewed the case. The district court found that the plaintiffs had standing to challenge the policy and demonstrated a substantial likelihood of success on the merits of their First Amendment claim. The court issued a preliminary injunction enjoining the county from enforcing its policy of closing magistrations to the press and public, except in extraordinary circumstances and as constitutionally permitted. The United States Court of Appeals for the Fifth Circuit reviewed the case, and in that situation, Caldwell County argued that the district court erred in finding that the plaintiffs had standing and in determining that they were likely to succeed on the merits of their First Amendment claim. However, the Fifth Circuit affirmed the district court's ruling, agreeing that the plaintiffs had standing and that there is a presumptive First Amendment right of access to magistrations. The court applied the experience and logic test, finding that both historical practice and the positive role of public access in the functioning of bail hearings supported the plaintiff's claim. The court concluded that the district court did not err in its determinations and upheld the preliminary injunction. While this case was brought by publications, I believe the ruling is clear that it would apply to individual members of the public as well. This is Dr. David D. Schein for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.